The question is, can you refuse to take a police breathalyser test until you've spoken to a solicitor? Well, first we'll talk about the preliminary breathalyser or the roadside breathalyser test. This is the portable device the police use when they suspect that somebody's been drink driving or if there's been an accident. There's no general right to delay things for legal advice at the roadside, and so you could not refuse to take the roadside breathalyser until you'd had legal advice. If you did refuse, you commit an offence, which you get a fine and 4 penalty points, but most likely you would then be arrested and taken to the police station. When somebody is in police custody, then they do have the right to legal advice, and that right to legal advice is either to speak to a lawyer on the phone or to speak to a lawyer in person. Normally the police have to delay interviews and things like that until legal advice has been obtained. But the High Court have looked at this situation and they say that when the police want to breathalyse somebody or even take a urine sample or a blood sample for a drink or drug driving case, then the police do not have to delay things for legal advice. So that means if you say to the police, I'm not providing a sample until I've spoken to a solicitor, then that's not a legitimate thing to do, and you could commit an offence of failing to provide. When you're in the police station, it's more serious. So if you're suspected of driving, you can get up to 6 months in prison, an unlimited fine, a minimum driving ban of 12 months. Now, the only rider to that was in a High Court case called Kennedy, and in that case, they confirmed that the police don't have to delay the procedure while somebody speaks to a lawyer, but if there happens to be a lawyer present, so for example, if a lawyer is immediately available on the phone, or if the lawyer that the suspect wants to speak to happens to be there in custody at the time and immediately available for legal advice, then the police should allow that to happen. But once again, that cannot delay things unreasonably. So any kind of delay for speaking to the lawyer, either in person or on the phone, would not be legitimate, and the police will be entitled to insist that the procedure got going straight away.